The committee will be taking oral and written evidence over the coming weeks in order to inform its detailed report on the framework to be published ahead of the summer recess. We begin today with 4 experts in the field who are all known to us on the committee. We're joined by Jess Sargent, Senior Researcher at the Institute for Government, Dr. Andrew McCormick, former Director General of International Relations for the Northern Ireland Executive Office, Anton Spisak, Senior Fellow of the Tony Blair Institute for Global Change, and James Webber, a partner of Sherman and Sterling. It's very good to see you all again, and we much look forward to hearing your evidence. Today's meeting is being broadcast, and a verbatim transcript will be taken for subsequent publication, which will be sent to you all to check for accuracy. I would like to refer to the list of members' interests as published on the committee's website. And perhaps I could ask the first question, just to get us going really, which is if you could give us your overall assessment of the Windsor Framework and the extent to which it resolves the problems that have arisen with the protocol. And in doing so, perhaps you could also give us your views on whether there is a difference of emphasis between the UK and the EU publications accompanying the Windsor Framework, and if you do detect a difference of emphasis, does it matter? So those are the questions which who'd like to go first? Jess, why don't we start with you?
Yeah, fantastic, great. I think overall, my assessment of the Windsor Framework Agreement is that it's a good pragmatic compromise solution between the UK and the EU. I think it addresses a lot of the concerns that have been raised by the business community and the unionist community in relation to the Northern Ireland Protocol. Importantly, by reducing the amount of paperwork and the extent of checks and controls on goods going between Great Britain and Northern Ireland. Now, it doesn't remove them entirely, which was the UK government's initial position, but I think there's some really good working to minimise them to the extent in which they are necessary to protect the EU single market. So I think that's really positive. I think the Stormont break does give the Northern Ireland Assembly the power to raise concerns about new EU regulation that could be implemented, and I think that's a big improvement from the situation under the initial protocol where all that law was just automatically applied. I think it's important to compare the two there. Now, there are obviously areas where the UK government in particular didn't get everything that it asked for. I think around governance is a big area there, where they haven't necessarily removed the role of the European Court of Justice to the extent in which they would have liked, but I think the focus on the sorts of issues that affect people in Northern Ireland, citizens and consumers, is the right focus. And other things like pets and the movement of pets, which might seem like a trivial issue, that has a really important impact on people who move regularly between Great Britain and Northern Ireland. And so I think it's important and good that they have resolved those sort of everyday issues. In terms of the questions of the difference of emphasis between the UK and the EU, I think we see this in a couple of areas. The first is on whether some of the derogations that the EU has provided on SPS in particular to allow goods that are produced in Great Britain and sold in retail in Northern Ireland to only have to comply with some parts of EU law. There are times where the UK government calls that a dual regulatory regime, and the EU has been very clear that it's not a dual regulatory regime. Having said that, when you look at the substance of what they say, that is pretty much the same. And similarly on the Stormont break, I think the EU has emphasised the sort of exceptional nature of it, that it is essentially an emergency mechanism, whereas I think the UK government has not necessarily presented it in the same terms, kind of suggesting it's wider. Having said that, if you look at the detail of both the UK and the EU documents, the actual conditions to which are the conditions that are applied to the Stormont break are the same. So I think it's more in terms of differences in terms of selling the deal rather than in terms of the substance. And I think overall it's a good landing zone after all of the sort of long-standing negotiations and challenges that we've had in negotiating this agreement.
Thank you very much for that. Pets are never trivial. What I didn't do was ask each of you to introduce yourself the first time you speak. We know who you are, Jess Sargent, so thank you very much for that. Perhaps I could turn to Andrew McCormick next to answer the same question.
Thank you, Chair. It's very good to be here virtually, and I'm using the freedom of having retired from the civil service to speak more freely than I could before. I think it's important in answering your question to just pause for a moment on the definition of the problems that we're seeking to address, or that the government and the EU were seeking to resolve. I think Jess has correctly focused on the pragmatic issues that affect both businesses and citizens, which were proving very, very difficult. A lot of them, in fairness, were known and identified during the negotiations in 2020, but not resolved then. I just would venture to say that I think there are 4 points that have emerged in the course of the last couple of years, which have become aspects of the definition of the problem, but which have quite weak foundations. Very controversially, I would say that the Act of Union, I don't think it has that much relevance in the 21st century. I think the basis of the Union of Northern Ireland and Great Britain is very, very well set in the Good Friday Agreement, which had the support of a majority of people in both parts of Ireland. A very, very important success, and we're marking its 25th anniversary. In contrast, the Act of Union was not supported by the people of Ireland, and doesn't really have a legitimate democratic basis, even if you look at it constitutionally at the time. I know that's a controversial thing to say, and I'm happy to go further if need be, but I venture to say that. Secondly, New Decade, New Approach did not promise the restoration of Northern Ireland's place in the UK internal market. And the reason for that is very simple, that under the protocol and with the nature of the way in which the Johnson government chose to settle Brexit, there is no basis on which you can have Northern Ireland having identical provisions as the rest of the UK. Some degree of difference is necessary if it's accepted that there cannot be a hard land border, and that's been the received wisdom from quite early after the referendum, and remains the government's clear position. The logic, the rest is logic in my humble opinion. Third point is that being a rule taker is not necessarily undemocratic. Norway, the EEA countries accept that they trade a significant amount of sovereignty in exchange for participation in the single market. And the position that the UK legitimately adopted when it passed the withdrawal agreement in January 2020 was to apply that same basic approach to Northern Ireland. There are important differences, which I can go into, which are really quite important, but the principle is that it's a legitimate democratic choice. There's plenty of arguments against it. Those are reasonable arguments to say you shouldn't do it, and those who favour Brexit will argue those points very strongly, but it's not axiomatically wrong. Finally, then, I would say that the Good Friday Agreement was not breached by the consent provisions made in relation to the protocol, and that was clearly the government's position in 2019. They wouldn't have made the declaration they did without being sure of their legal ground that the consent provisions were legitimate, because international trade was and has been an accepted matter since 1921. So the Assembly had no role in relation to matters of international trade. Giving the Assembly uniquely a voting role was an unusual measure, and it was legitimate on that. As the government argued at the time, it was legitimate to do that by simple majority, and there is no provision for cross-community consent in relation to anything that is of that unique nature. So I come to it then really very simply. if you accept the Brexit trilemma, in other words, that if the land border is open, there have to be checks somewhere. If again, if the two limbs of the trilemma that the government has chosen are to withdraw from the single market and customs union, and to have no land border, then the remaining question is how to make sure that the checks that are needed at points of entry into Northern Ireland are as undramatic, as low-key, as minimal as possible. And I think the work on the Windsor Framework has addressed that primary problem. So, long-winded answer, but that was the problem that could be addressed. It was the only problem that it was actually reasonable to try to address, and the Windsor Framework has made good progress in that. And then added in, will come, as you said, to the strong break, which has, as Jess said, an important dimension. But that was the test. The Windsor Framework is very, very much better than the protocol as applied and as agreed originally. So that's my summary.
Well, thank you very much for that. That's very helpful. Let's move to James Webber next, and then we'll come on to Anton Spizak. James Webber, over to you.
Hello. So thank you very much, Chair. So I'll do a little introduction, because I'm a competition and state aid lawyer, originally working in Brussels, now working in London. My main expertise in this area is in respect of state aid and Article 10, right? Although I have been quite strongly involved in other areas, I will make that slight caveat at the beginning. In terms of your question, so I take the view that the Windsor Framework is an improvement on what we had before, but that shouldn't take away from the fact that what we had before was very poor indeed. I take the view that the protocol was unnecessary, as a way to protect the single market, as a way to solve the trilemma, as Mr. McCormack just described. And I think I've given evidence previously to the committee on the alternative solution that sort of I and others were working on at the time of the original withdrawal agreement negotiations. That's come and gone, but at the time it was called sort of mutual enforcement, right, which would have not placed the border in the Irish Sea, would have created the difference in some way about the application of EU law within Northern Ireland, but would have solved the problem by a bilateral arrangement between Northern Ireland and the Republic of Ireland to enforce each other's trade rules and collect the duties that were owing. That period of history has passed, so I readily concede that, and we are with the protocol as it stands and the solution that it presented. So I would say that the protocol and the problems it presents, the Windsor Framework ameliorates some of them. But it has created fresh problems as well too, right? And we'll come on to this sort of particularly in terms of state aid. And Article 10, which was the protocol provision and is the provision in the Windsor Framework about state aid, that is applying state aid rules to the entirety of the UK, remains an extremely unusual and problematic provision, which will have which has serious effects for the UK's sovereignty, and which was very unwise to continue in its current form. The other area is that because the grace periods are ending at the same time as the Windsor Framework comes into place, some of the problems that were in the Windsor Framework is trying to fix weren't actually fully realised because of the application of the grace periods in this period prior to now. And so I think when we come to look at the red channels and the green channels, we will perhaps see some of those issues come out. And the solution that the Windsor Framework represents is indeed a solution versus the protocol, but may actually feel like a more intense level of Irish Sea border versus the grace periods that we have in place today.
Thank you. Thank you very much for that. Anton Spisak, over to you.
Thank you very much for the invitation today. I'm Anton Spisak, I'm Senior Fellow at the Tony Blair Institute. My view on the Windsor Framework is that it is the best practical answer to the dilemma that the objective of eliminating the border on the island of Ireland in the wake of Brexit has created, and that the decision to leave the single market created at the same time. I believe that it significantly improves the status quo, which is the full application of the protocol, and at the same time it addresses some of the concerns over the democratic deficit, which is related to the automatic adoption of EU legislation under the protocol. That process has significantly changed under the Windsor Agreement, and we can talk about the detail of it, but it does give the elected Northern Irish representatives a far greater say over the application of new and changed EU legislation. I think that's a really important concession, actually, that the European Union agreed, and it significantly moves from the initial position, which was that the mechanism for dynamic alignment is sacred, and there wasn't any initial scope for changing that mechanism. What I'm a little bit concerned about is the political dimension of
Sorry, the what dimension?
Is the political dimension of this agreement, and that is the fact that I think there is a significant risk that the storm and break, and we can get onto it in a second in a detail, will create a potential for future disputes, essentially, but also that it will it might, in some circumstances, encourage hostility towards the EU, and that it might be tested in ways that is not currently envisaged under the current arrangement. And I think that's where we get into your second question, which was about the differences of emphasis between the UK government and the European Commission. I think there is a big difference of emphasis, actually, in description of the storm and break, because if you look at the text that the EU set out, it talks very clearly about, I believe, the most exceptional circumstances and the use of that break only as a matter of last resort. The way that the UK government has tried to portray the storm and break has been quite different, and has been as essentially a mechanism for allowing any group of MLAs, at least 30 of them from at least 2 different political parties, to use that break. So I think there is a big difference of emphasis, potentially of understanding of what that break is meant to do, and that might create its own difficulties, but I'm sure we'll get onto that in a second.
Well, thank you very much for that. I mean, we will indeed get onto that now, because I think it's been clear to all of us that the Stormont break is one of the more important things to discuss during this session. I thought we might move on to it at this stage. So, Lord Hayne, over to you.
Thank you, and you're welcome, and it's good to have you with us. Perhaps I could start with Jess's description of the Stormont break as an emergency mechanism. And maybe you could elaborate on the extent you think it will ever be used, and the implications, both legally and of its operation. I'd like then to follow up with a sort of subsidiary question to you all once we've addressed that, on the general principle about the scrutiny regulations that were passed today, which seem to me to have quite significant implications, but I'm not sure of your views on that. But if we could start with the break generally.
Yeah, absolutely. I mean, so in terms of characterising it as an emergency mechanism, in that I was quoting well, technically the text of the deal, and also the EU, as Anton said, that was an element that they were keen to emphasise in their own kind of document. Where that emergency and last resort comes from is a reference to the terms under which the petition of concern can be used in the New Decade, New Approach deal, and the UK government have said that the use of the break should be kind of equivalent to the use of the petition of concern in that circumstance. So that's where that idea comes from. I think we haven't had much chance to test out the petition of the concern under the new arrangements, but I don't think that will be as strong a legal test as the conditions around it being a significant change to EU law and having significant impact on the community. I think it's just intended to signal that it shouldn't be the first thing you reach for, essentially. You need to kind of have exhausted every other potential to find a solution through the Assembly and through discussions with the UK and the EU before that's used. So I think, the more important tests are those around it being a significant change and it having significant implications. In terms of how often that test is likely to be made, it's a little bit difficult to predict because we don't have a clear sense of how EU law might change over time, and therefore how substantial those amendments or updates to the existing regulations might be. I can foresee a situation in which that might happen, where the EU updates a piece of legislation that means that there is quite significant divergence between Great Britain and Northern Ireland that isn't captured under the sort of SPS derogation that already exists under the Windsor Framework. So if, for example, the EU changed certain laws on kind of product standards that GB hadn't, then that could create a real problem in importing certain products from GB. That would meet the test of that being a significant change and having significant implications on Northern Ireland, because it would affect consumers' ability to be able to purchase certain goods from Great Britain. I think one of the questions is whether changes in EU law will be implemented through an update or an amendment to an existing EU law, which is covered by the Stormont break, or whether that will be a completely new act which goes through a slightly different procedure. Under that procedure, the UK still has the opportunity to veto that in the joint committee. And as part of the statutory instrument that was made, that's just been voted on in the House of Commons, the UK government has committed to provide an opportunity for a cross-community vote on that, and saying it will only add that new EU Act in the event that there is cross-community support for that new Act. So there's a kind of different type of break actually there that's been extended to new Acts as well as amendments or updates. And
on that cross-community versus the 30 MLAs, how does that, in your view, kind of play out?
So I think it essentially creates a two-stage process for the Stormont break. The first stage is the 30 MLAs triggering it on an amendment or an update, and that leads to its automatic suspension as long as the UK agrees that the conditions for triggering it have been met. So you're in this position where that EU law no longer applies. But then there's sort of a second stage where the Joint Committee are required to consider the amendment or update on which the break has been pulled as if it were a completely new law, and at that stage there's another opportunity for the Assembly to have input, and that's when...
On a cross-community basis?
Yes, and on a cross-community basis. I think part of the reason that the process has been designed in this way, and having sort of several different points at which both the Assembly have the opportunity to express a view, but also where there's a sort of mediation point for the UK in determining where the conditions have been met or coming to a decision with the Joint Committee, is to allow space for discussion, is to allow space to try and find an alternative solution. Ultimately, we shouldn't see this procedure as, a cliff edge, that the first port of call should be that EU Act doesn't ever apply, because we know the EU has the opportunity to take remedial measures, and that can also just create some challenges about Northern Ireland's access to the EU single market. So I think we should conceive of within this process as lots of opportunities for the UK and the EU to try and agree another solution, and that could be through the EU providing derogations to the Act that it's proposing. It could be through the UK or GB law changing in order to prevent certain types of divergence. So I think we should really be seeing this as an opportunity for Northern Ireland to raise concerns, that ultimately if they do, or certain communities in Northern Ireland to raise concerns, if they do, there is a possibility that if a solution is not found, that EU Act will no longer apply, but our priority should actually be to try and find solutions before we get to that point. And I think that's the really underappreciated part of the Stormont break, is it creates a very strong incentive for both the UK and the EU to actually come to a mutual agreement on this, rather than get to that cliff edge point where nobody really knows exactly what would happen.
And Anton, you were nodding at that point. I think James might have been as well, and I'll come to you in a minute.
At certain points, probably, yeah.
Yes, no, I broadly agree with Jess's description, I think. I mean, I think just to take us a little bit step back, it is a very significant improvement on the status quo, which is that all EU legislation that changes legislation that is currently listed in the annexes, and that's about 300 plus pieces of legislation, would be automatically updated without any involvement of either elected Northern Irish representatives or UK government. And that status quo essentially falls away now, and there is now a very clear process by which the European Union would first notify the UK government and the Northern Irish Assembly, and that's where we get into the democratic scrutiny regulations, it would also notify the Northern Irish Assembly of any upcoming changes to EU legislation as it applies to Northern Ireland. And then there is a process which just described where that Stormont break could be used by a group of MLAs under certain conditions. I would say that those conditions are quite tightly drafted, so it's definitely not an opportunity to raise a petition of concern for any change to existing EU laws that apply to Northern Ireland. There are those two conditions that have to be met simultaneously, and one of them is that essentially the nature of replacement EU legislation has to have changed, and also it has to have demonstrable impact on everyday life of communities in Northern Ireland. What I would say is actually what has also changed, and that's just adding to Jess's description, is the process for new EU legislation coming into the protocol. So just to give you an example, the European Union is currently legislating for the so-called carbon border adjustment mechanism, which would impose certain tariffs for carbon-heavy products like steel or aluminium. The EU initially envisaged that that's...
Practical effect, just if you could explain that in later, and sorry to interrupt your flow.
So, for example, if you are a GB steel producer and you are exporting steel into Northern Ireland, in some circumstances there could be a duty applied to that steel under this new mechanism. But this provision, this legislation, has not been added yet to the protocol. And the only way for that to be added onto the protocol would be by a joint committee taking a mutual decision. And at that point, you would expect the UK government to raise some questions about this and say, well, this is all very well, but actually we would like to see what is the actual impact of this legislation on the businesses in Northern Ireland and on the citizens. What the UK government has now proposed in the statutory instrument is that any decision that it would take in the future at the joint committee when it essentially decides on its position would have to be preceded by a motion in the Northern Irish Assembly, and that motion would have to be passed on a cross-committee basis. So that's a very significant change to the way that this process will work in practice, and it gives, I believe, elected Northern Irish representatives a far greater say over any future changes to EU law as we have previously seen.
So to that extent, it addresses the democratic deficit that lots of people, including it had happened to myself, have been concerned about.
I believe it does, to a very large extent, address that concern.
And James, you were nodding and disagreeing in both at the same time.
I think
you could say something about the state aids issue and all of this.
Yeah, well, I think on the Stormont break...
We'll come on to the state aids later.
Sorry. Yeah.
I would say 4 points, I think. The first is that the Stormont break doesn't apply to all EU laws across the whole of the width of the protocol. It's limited to those set out in headings 1 and 7, and then 7 to 47 of Annex 2, and the EU's laws which define the relief from duties on personal possessions under Article 5.1. So there are laws outside of the scope of the protocol, scope of the Stormont break, which are going to be applying in Northern Ireland. For example, VAT, the Customs Code, the Single Electricity Market, State Aid, Trade Defence. So that's the first point. The second point, which has been alluded to by Jess and Anton already, is that the ability to exercise the break is quite strongly circumscribed by, tightly drafted, I think is a good phrase. So the law objected to must significantly differ, right, from the previous one. And given that the scope of the EC, or the TFEU, is the TFEU itself, right, defines the legal basis on which any EU law has to be founded. What significantly differ means, compared to the legislation the EU has on the books already, is going to be an open question. The second is the significant impact which is specific to everyday life of communities in Northern Ireland and which is liable to persist. So there's some echo there, although it's more narrowly drawn than the Article 16 criteria that we've discussed previously. The determination of that threshold is also subject to EU dispute. The EU has the right to raise a dispute in the arbitration through the arbitration mechanisms of the withdrawal agreement as to the applications of those criteria, and that's an important differentiator from the EEA agreement, where the EEA states are able to decide for themselves whether or not those criteria apply, and then the remedy that the EU has is suspension under the EEA agreement. And that actually is the third point, which is that the remedial measures that the EU is empowered to introduce in response to activation of the Stormont break are cast wider than the suspension of the treaty. So in the EEA, which is essentially the model for this concept, that permits suspension of the benefits of the treaty, whereas here we have a different formulation which refers to remedial measures. Now, I think, Jess, when you were addressing that, there's quite a strong assumption that the EU will act in good faith and that those remedial measures will be in proportion to the threat to the single market represented by the law you're attempting to disapply using the Stormont break. But that's essentially a political sort of obligation. The remedial measures are for the EU to decide. And then the fourth point, which is building on something that Mr. McCormack commented upon, is whether or not it does require the cross-community consent provisions under the New Decade, New Deal, because it's not obvious. I don't think that's clear, and I could be wrong, but I don't think that's clear. And insofar as these provisions are not sort of GFA provisions, as it were, because they're an exception, as Mr. McCormack was describing. Yeah. Then it's not actually obvious that the cross-community consent provision would apply to me. That would be my fourth point.
And Andrew, your take on this, and I would be particularly interested also, since the question of the Democratic Scrutiny Committee's come up, this new proposal in the Assembly, which seemed to me to be an advance on where we were before this. But it seems, is it subordinate to the Northern Ireland ministers? I'm not clear what the relationship is between, given your own Northern Ireland office experience, between the Northern Ireland ministers is. Would the Scrutiny Committee be able to interrogate Northern Ireland ministers, or is it confined to the Stormont arena?
So I find that was one of the questions that struck me looking at this in the last few days, was the absence of any mention of the devolved ministers in the scrutiny process. But I do think overall it's a helpful dimension. I think in general terms, my hope would be that it's more difficult in theory than in practice, that in practice most of the relevant amendments to EU law will be not significant or not having a major impact on everyday life, or as others have said, the tests in the documentation are high and are challenging. And while, as Jess said, we need to avoid cliff edges, there is a potential cliff edge, and this links again to the important points James made about EEA, and where this was one of the differences that struck me strongly about the position Northern Ireland would be in compared to the EEA countries. For them, the choice is relatively simple. If something is so significant for their economy that they're prepared to put their participation in the single market at risk, then that's a judgment with high stakes and potentially very significant consequences. But it's a choice for a sovereign state. The dilemma that could emerge, trying to look at this at worst case, is that there is a changed EU law which increases divergence with the rest of the UK very significantly, and that seems to me the why, the kind of reason there would be for the criteria to be met, and therefore there's the choice for Northern Ireland is who to stay aligned to. It's not Norway and the other EEA countries they have one big partner market, not, as in our case, two. So that's an enormous difference, and then does bring in concepts of identity and legitimacy that need to be thought about very carefully. Where I have a big concern, I think James is correct to say that the position on cross-community voting was not clear in the original documentation. However, looking at the SI that has just been passed by the Commons, that does seem to introduce a final applicability vote that would be subject to cross-community consent. Now, again, worst case, if the consequence of that vote is to put Northern Ireland's participation in the EU single market at risk, then world's most exciting economic zone becomes an issue that could be being overturned by a minority. So I would question whether a decision of that substance should be made on the basis of a minority view in Northern Ireland, which is the potential consequence.
Sorry, could you explain that?
So if something requires if the application of a law which is essential in the EU's view to allow Northern Ireland's continued participation in the single market, I find it hard to imagine how that could arise, but theoretically, that's why it's maybe more difficult in theory than in practice. Theoretically, it could arise, and in that circumstance, if the new law does not get cross-community support, it doesn't apply, and the EU invokes, as James said, remedial measures, which certainly could include the kind of provisions that are in the EEA agreements. So that's a high risk, and for me, when I worked through in the original work on the Good Friday Agreement, running up to, some of this goes back to 1992, the principles of how you take decisions, the cross-community votes were required to change the status quo, and the problem is the status quo is ambiguous in this case, because you can look at the status quo generally, as in Northern Ireland participating in the EU single market, or you can look at the status quo legalistically and narrowly and saying it's this particular body of EU law. One of those is going to change. For me, the primary vote should be the original decision on consent that was provided for in the original protocol, where the Assembly looks at the principle of the application of the protocol, or the defined articles of the protocol, and consents or does not consent, and ideally would consent on cross-community basis, but explicitly the provision in October 2019 was that if there was only a simple majority, it would stay in place for 4 years. So that's the general and overarching position. And if the majority of the Assembly want that to be the position, then it seems to me a bit of a contradiction to then say that on the basis of a particular amendment to EU law, the whole position might change radically. I would just ask the question, is that democratic? I can understand entirely why they're trying to do it, and the other point is it should work if the tests are applied rigorously, and therefore a really big issue of principle arises. What I observe, having worked for Northern Ireland ministers from 98 to 02 in the first Assembly, and then from 07 onwards, there is a tactical ingenuity, if I put it as gently as that, as to how the rules can be applied. That's characteristic of our parties, and it's part of why we are where we are today without a government. And so creating tactical opportunities, that's where, again, good faith. Will the words as agreed with the EU be applied in good faith? that's to me very, very important. It would be better if we were in just, I think, if there was more time for scrutiny, again, for an open and transparent process that allows businesses to express their views pragmatically about what would be implied by changes. All these things come into how the concepts would work out in practice. I remain hopeful in principle. It's a better thing to have than not to have, but the detail is quite challenging.
Could I just conclude this by just asking briefly for you, Andrew, but then the others, to say something about the relationship between this new Democratic Security Committee of the Assembly, the Northern Ireland ministers, and Northern Ireland ministers, Northern Ireland office ministers, i.e. UK ministers, and MLAs. I don't want to overstay my welcome, but this is quite an important issue.
No, it is an important, but if I could ask people to be, because we are otherwise going to run out of time, to be quite brief, and then we've got Lord Thomas also on this question, but please, a very important question from Lord Hayne. Who's going to go first?
Can I just say briefly, in a sense, it matters less in practice than in theory, because the parties behave pretty coherently in the Assembly. So I do find it odd there's no rule for ministers, but if the parties work according to party mandates, then you can see a process. You would expect to see scrutiny. It would be better if that's open and transparent. But I think the logic of the process and the degrees of scrutiny have an internal coherence.
James, briefly, and then...
I'm outside my expertise, I'm afraid.
Okay,
I won't
no
have anything
problem.
to that.
Anton, and then Kate.
I would say...
Sorry, Jess.
I would say it is an important addition to the whole process, because what it does, essentially, it introduces a level of scrutiny that was not available previously, and that is absolutely essential. And it was one of my objections to the original protocol, which was that it did not provide sufficient opportunities for, on the one hand, Northern Ireland elected representatives to engage with upcoming EU legislations in the pre-legislative stages, but also for the UK government to be sufficiently informed of what's coming up in the pipeline. I think both of these concerns have now been broadly addressed. And actually, if I can just draw the attention of the committee to one very specific technical point here, there has been a change to the rules of procedure of the Joint Consultative Working Group, which is essentially a technical committee underpinning the protocol. And the EU now has an obligation to inform the UK government well in advance of any potential changes. And there is a new kind of consultative mechanism that would, I think, significantly help to ensure that actually any changes are brought to people's attention well in advance. So I see it as an improvement. But I do agree with Andrew on the potential risks here, which are that this mechanism can be, I think, subject to political influence, and it can be under significant pressure if it's not used correctly and as defined in the framework. So I think there are some risks, but on the whole, I think it is a big improvement.
Jess?
Yeah, just briefly, in terms of there is precedent for UK ministers to appear before devolved committees. It's actually kind of fairly common, but very inconsistently applied. It kind of depends whether ministers decide to accept that invitation. So I think one thing that could be done is to ask UK ministers for assurances that they will appear before this new committee, where there is an issue within their responsibility that they may be required to take a decision.
Not just NIO ministers, but all UK ministers.
Yeah, there's definitely precedent for that, and likewise there's precedent for EU officials to also appear before committees, including the Northern Ireland Assembly committees. That has happened before, and so I think that would be a very valuable part of the process.
Thank you.
Lord Thomas.
I've been looking at the EU side of it, and I quote from their question and answer explaining the Windsor Framework. They say this: the storm at Brake is a new emergency mechanism that will allow the UK government, at the request of 30 members of the Legislative Assembly in Northern Ireland, in the most exceptional circumstances, as a last resort, as set out in a unilateral UK declaration, to stop the application of amending or replacing provisions of EU law that may have a significant and lasting impact specific to the everyday lives of communities in Northern Ireland. Lord Haynes' first question was, will it ever be used to deal with that? And the problem that I see, and I'd like your comments on it, is that this is dealing with something that's come from Brussels, whether it's amending or original or whatever, and is complete and is then stopped, as opposed to more input in the pre-legislative process. And surely that is where the emphasis should have gone. Well, Andrew,
yes.
Let's have your view on that.
Yes, no, I think that's even with the way things are, that's the right approach. That is entirely the right approach. It's what the EEA countries do, and their access to working groups and so on has been very important for them in the ongoing evolution of the regulatory regime in the acquis. So for me, there will be a big need, and this is going to be a very major demand on Northern Ireland Civil Service resources looking ahead. The office that the NICS has in Brussels will need to be very active, need to be liaising, understanding what's coming through, because actually once, as I'm sure many committee members are well aware, once a proposal emerges, it will be the result of probably quite a lot of difficult compromise among the 27. And so to ask at that stage to go back around the loop and say, we wanted to change for this reason, to get that agreed by all 27 or sufficient on if it's under QMV, then there's quite a challenge there. Better to be sufficiently well informed, flag up at a very early stage to say, if you do that, we have a problem. That doesn't create instant solutions, but it seems to me to give a much better chance of dealing with the issue in a pragmatic way than waiting. So that the levels of scrutiny after publication are important, but getting upstream and ahead of it is to me vital.
Thank you. I wonder if we could have further comment.
Yes, I mean, I would absolutely agree with Andrew. I think it's very important that these issues are considered before the EU Act is published, in part because the timescale actually for using the break is very short. The break has to be triggered, the UK has to give the EU a notification that the break has been triggered within 2 months of the EU Act being published. So that suggests that actually a lot of the heavy lifting needs to take place before the actual publication of the Act. And I think that is foreseen to some extent. Sorry, I was just finding the part of the statutory instrument that says that the committee, the new committee that will be established to scrutinise it, can be given notification of EU acts that have been proposed, which suggests that there will be some level of sort of pre-legislative scrutiny here. There's also provision in the Joint Consultative Working Group that the EU is required to share information with the UK about upcoming acts, and then I presume that the UK is intended to notify the committee. Now, that hasn't really been happening very well at the moment, in part because of the poor relationships between the UK and the EU, but also because I think there's not a really strong incentive to do it. I think both the UK and the EU can kind of carry on with their own regulatory proposals without really thinking about Northern Ireland. As I said earlier, I think actually one of the really positive consequences of the break is it creates a so what if they don't, share information at an early stage and hold these discussions and consider Northern Ireland in developing EU proposals, then they run the risk that later on the break might be triggered. So I think the break creates an incentive for that engagement at an earlier point.
Well, there doesn't appear to be a place for Northern Ireland elected representatives, or no explicit place for Northern Ireland civil servants in the pre-legislative consideration.
I would probably push back slightly on this point, because I think as part of the changes to the Joint Consultative Working Group, there is now an obligation on the EU to inform the UK government of any upcoming changes, and that's not, as just explained, not just after an act has been published in the journal, but also in the stages when the act is being passed. That's my interpretation and reading of that provision. So I would just probably add that in practice, this all depends on how good are the working relationships between officials in the European Commission and in the EU system and the UK government, including in the Northern Irish Executive. And if those relationships are strong and productive, then I think quite a lot of heavy lifting will be done in that early stage through the technical committee. But
Northern Ireland officials included?
It's not clear to me, but I wouldn't see any strong reason why those officials should not be included as part of that process, because the definition is very broad.
Yeah, I understand that the UK government has committed to including either Northern Ireland politicians or officials, depending on who's appearing in its delegations in meetings of the Joint Committee and subsequent structures.
But I do think...
At the moment, I think only the First Minister and the Deputy First Minister have a right...
At the Joint Committee
are
level.
invited, not have a right, but they are invited to the Joint Working...
Yes.
The Joint Consultative Committee out there,
Yeah, that's at the Joint Committee level. There are several kind of structures under it, some of which are just attended by officials. And again, the UK government has committed that the appropriate level, essentially, would attend as part of the delegation.
I think we're going to have to move on because we've got a long way to go. Are there any other points there, or should we move on to Baroness Ritchie?
Thank you, Lord Chair. You're all very welcome. In the background briefing to the political declaration by the European Commission and the UK government, it states that the framework reflects the full commitment of both to protect the Good Friday Agreement of the 10th of April 1998 and its subsequent implementation agreements and arrangements. So in that respect, how would you assess the Windsor Framework against the UK and the EU's joint commitment to protect the Belfast Good Friday Agreement, including its subsequent implementation of agreements and arrangements in all its dimensions and strands? And by that I mean Strand 1, Strand 2 and Strand 3. And I apologise, I forgot to declare an interest. I'm a member of the Board of Cooperation Ireland, and of course I'm a former member of the Assembly and a Minister of the Northern Ireland Executive several years ago. So I'll start with Jess.
Absolutely. I think the agreement does go a long way to trying to protect those three strands. I mean, firstly, the purpose of it is to try and restore the domestic institutions, which are obviously a very important element of this. And in doing so, trying to address some of the concerns that have been created about that with the kind of NIGB relationship, which is itself is not a specific strand, but is also an important dimension here. It's maintained north-south cooperation, including in maintaining frictionless action between the two. I think one thing that's important to emphasise is that obviously the north-south institutions, including the North-South Ministerial Council, have been in abeyance longer than the Assembly and the Executive, actually, in part a protest of the protocol. So I hope if we are in a situation in which the Assembly is restored, that we will also restore those north-south institutions. And I know there's been some legal challenge to that particular action, and so I hope that will be part of any progress if we do see it. But I think actually also one of the things that the agreement does very well is re-establish the east-west dimension and improve relationships between the UK government and the Irish government, which have really suffered as a consequence of Brexit and this ongoing disagreement. And I think it's actually been very heartening the extent to which those have seemed to have repaired quite quickly after this new agreement. So although there are obviously ongoing problems, I think the Good Friday Agreement requires ongoing work and ongoing support in order to continue the functioning of all those strands. But I think there are elements of this agreement that speak to all three of them.
Thank you, Jess. Anton?
I would perhaps just add one point to that description by Jess, and that is, I think that the EU, in moving in its position and in showing more flexibility in how it applies EU law, and it now applies EU law essentially by exempting Northern Ireland from aspects of its own legislation, which is quite an important, I think, concession by the European Union. I think it reflects that special status of Northern Ireland and the special conditions that the Good Friday Agreement established. So I think that is now more reflective in the European Union's position and in its own legislation and how it treats Northern Ireland. I think the other aspect that I would add would be in relation to Article 6.2 of the protocol, and that's a little clause which says that it is really important to ensure Northern Ireland's place within the United Kingdom. And there has been actually an amendment through the Windsor Framework to that particular clause, and the two sides have committed to giving each other more flexibility to how that provision is implemented, which again I think speaks to that East-West dimension and its strengthening through this arrangement.
Thank you. James?
So my comment would be that the Northern Ireland Protocol, was about protecting the EU single market, right? And the Windsor Framework is also about protecting the EU single market. That's its purpose. The Good Friday Agreement had nothing to say about trading goods, which is what the Northern Ireland Protocol and now the Windsor Framework are about. So it's not surprising, I think, that there's a level of dissonance between the two documents. Right? The Windsor Framework has made some progress towards recognising the Good Friday Agreement, but it still doesn't use the institutional architecture or even really refer to the institutional architecture of the Good Friday Agreement in terms of the British-Irish Council, the obligations on the Irish government and the British government to reach bilateral agreement on EU issues, which is part of the Good Friday Agreement. That's also not present. So I think it's probably a step forward. The EU seems to be increasing its understanding of some of the issues and complications, but it's ultimately not really about the Good Friday Agreement. It's about protecting the EU's single market, in my view.
Just a supplementary to that, would you accept the fact that the Good Friday Agreement was made and people were very conscious then of our common membership of the European Union? In fact, you could say that there were models used in the European Union that translated in terms of bringing people together, power sharing and reconciliation. So therefore, some would suggest, and would you agree with that, that there could be
to an extent, that's definitely true, right? The Good Friday Agreement didn't need provisions on trading goods because we're obviously both members of the single market. So at one level, that's absolutely right. At another level, the Good Friday Agreement refers to bilateral, UK, Republic of Ireland, and the institutions of Northern Ireland, and doesn't make any reference to the institutions of the European Union. Whereas the Northern Ireland Protocol and Windsor Framework is all about the institutions of the European Union, and the kind of interlocutor is the European Commission and not the Irish government. And so in that's sort of what I mean. That's a fundamental difference, right, between the two agreements, I think.
Thank you. Andrew?
Just, yes. I'll go back to the beginning, really, is that, as others have said, trade issues were not foreseen as an issue in 1998. The assumption of ongoing EU membership was maybe not explicit, but it was just not taken for granted, maybe. And my comment would be that there is no outcome of Brexit that doesn't disturb the delicate balance. That's a phrase that's been used a lot. The delicate balance of the agreement is disturbed in some way. I think it's also a matter of fact that the threat of a hard land border had a head start of at least a year conceptually in the rhetoric of the debate before anybody really realised and focused on the fact that there was potential risk of dislocation between Northern Ireland and the rest of the UK. So it can certainly be argued that if you only looked at the issue in constitutional terms, then the trilemma would be resolved by a hard land border. That there's strong constitutional arguments for that, and there are land borders elsewhere across the one between Croatia and Bosnia last year through a queue of lorries. But if you add into the mix both the pragmatic impact and the dislocation of society, the case for managing the checks in a minimalist way through the ports of entry is the case is there. It becomes it probably should have been approached as an open political judgment in saying, oh, we now have a problem. What's the most pragmatic solution to it, rather than getting into. I'm trying to rewrite history here, and it's maybe not helpful. But we've been on a long journey, getting it back to what I would quote from Article 1.5 of the agreement itself, which says we the participants pledge we will in good faith work to ensure success of the arrangement established. The institutions, as you said, are interdependent. The strands are interdependent. There is an issue arising from Brexit in relation to Strand 2 because North-South cooperation was affected and there was a perceived threat. There is also a very significant issue. Of course, though, there was no discussion in 1988 on the relationship between GB and NI. But if the fact was Northern Ireland was remaining part of the UK, how that operated remained as before from principles established in 1921 and in the Constitution Act in the 1970s, rather than being reinvented. So the powers given to the Assembly were the issue in Strand 1 was how those would be exercised and how power sharing would work. So these are unforeseen problems. To me, the better way would have been to look at them in an open way, to say, well, we've got a set of problems here. What's going to be helpful? What's going to provide a pragmatic compromise that is as close as possible to the spirit of the agreement, but attempting to apply its letter when it didn't say anything about these issues is really very difficult.
Thank you very much.
Thank you very much. Baroness Alone.
Thank you, Lord Chair. I'd like to ask you for your assessment of the Windsor Framework's provisions in relation to customs procedures and the movement of goods between GB and Northern Ireland, including the arrangements for green and red channels and an enhanced trusted trader scheme, handling of tariff rate quotas and the system of commercial data sharing. And then finally, how would you assess the particular arrangements for the agri-food retail trade into Northern Ireland? And perhaps I start with James, if I may.
Yeah, sure. So I'll make my comments quite brief on this. So conceptually, the red lane is the default. So, the red lane is what applies, and then there are a set of exemptions where you can use the green lane, and the green lane concept is that they would permit import from GB to Northern Ireland where processing in Northern Ireland is for the purpose of sale, a limited number of things. So certainly better than we had before, but a limited number of things. So sale of food to an end consumer, so that fixes the M&S, the sausage problem. The incorporation of processed goods into a permanent structure, the provision of recipient of health care or care services by the importer or subsequent entity, not-for-profit activities by an importer, and final use of animal feed. So there is also a safe harbour for SMEs, so those with an annual turnover of less than £2 million. So that's the green lane operates by way of exception if you can qualify under any of those provisions, and it removes the need for checks. One of the difficulties with the red lane is that everything else then comes in under the red lane, and you've got items where tariff obligations may apply, because notwithstanding the TCA, you still have to comply with the rules of origin requirements of the TCA in order to benefit from the tariff-free treatment, and so you've got sort of tariff potential barriers, or at least showing compliance with rules of origin, which makes importation from GB into NI difficult if you're using the red lane. There is also sort of the remaining, the structural problem, the original structural problem created by the design in Article 5 of the protocol, which is that everything is caught by the EU rules, and because everything is at risk of subsequent importation to the EU unless it's decided not to be. That structure has been retained, right? So essentially, the green lane represents a further definition of things which are not, quote, at risk of further importation into the EU. But the at-risk concept is still something that the EU sort of controls. So, the better approach would have been to agree to switch that, right, where the things which were at risk were truly at risk, right, based on the evidence of actual trade flows across the north-south border, either statically looking back or dynamically based on the market surveillance of trade surges and such like, and using that to inform what the concept of at risk means, rather than essentially the green lane operating by exception to the default regime.
Okay. Thank you very much.
That was your original concept, in a way, wasn't it? That the way of enforcing the differences would be drastic, draconian penalties for people who cross the border.
Well, it would involve the use of the criminal law to enforce the rules of the other party.
Yeah.
So that exporting a product that did not comply or had not paid the duties would be a criminal offence in the exporting jurisdiction. That was the fundamental idea behind mutual enforcement. But my commentary on this is based on the balance of where does the exception lie. So the green lane is an exception to the red lane, right? And that means that the exception is drawn reasonably tightly, and you can have lots of examples where you're outside of the exception, where the EU gets to continue to decide what is at risk. And that, in my view, is an excessive, quite fundamentally excessive. If we look at the
I think we have to move on because we're getting terribly late.
Yeah.
Thank you. Can I
Sure.
carry on to Jess, please? And then to Anton, and then to Andrew.
Yeah, absolutely. I'm not a trade or customs expert, so I'll be fairly brief on this one. But I think the points I'd raised were around sort of implementation and assuming that ensuring that the scheme works in practice. I think it's good that it builds on existing schemes like the UK Trader scheme that we've already had experience of operating. I think already the UK and the EU identified some problems with that have been remedied through this solution. But I think that suggests that there might need to be a little bit more wriggle room for further adjustments as this scheme kind of beds in and is actually being implemented. I think another point I would make is around UK administrative capacity, because in some cases where there's less burden on the traders to provide information around customs, some of that burden falls on the UK government and the Trader Support Service. So ensuring that maintains a free service that traders can use, I think is really important, and there should be assurances on that. And also the need to maintain trust. I think the data sharing agreement between the UK and the EU and the new database, the bespoke database that the UK government has built, has been really important in being able to reach this agreement. So continued data sharing and building of trust is really important there. Just to quickly touch upon the question around the agri-food retail trade scheme, this was actually one of the areas where I was surprised that the EU had actually moved this far. We'd heard for a long time that this was not something they were going to budge on, and I think what we've landed on is actually a really pragmatic solution where there is actual risk of diseases spreading across borders, that those rules have to be complied with, but other things around consumer protection, if the products are coming from GB, don't need to comply with those requirements. That solves a real actual problem that we could be facing, for example, in the coming years when the UK UK changes its definitions of gene editing, that was a problem that could have prevented goods going from Northern Ireland. That's now been solved, and I think that's a really positive development that will maintain supermarket supply chains, which was one of the primary concerns about the application of the protocol.
Thank you very much. Anton?
I would say that quite a lot will change in practice, because we have to remember what is the status quo at the moment, which is, or what would it be a status quo if the protocol had been fully implemented, and that would have been GB businesses moving any goods into Northern Ireland, whether they're intended for the final consumer in Northern Ireland or elsewhere, facing the exactly same regulatory and customs burden. And we have now moved completely from that default, and now there is a really important distinction here, which is based on the final destination of goods. And to the extent that the goods are destined for Northern Ireland and for the final consumer in Northern Ireland, essentially for all the purposes of movement of those goods from GB to NI, they will be treated very, very differently. And the burden on businesses will be very, very heavily reduced, but not completely eliminated. It's very important to say. But where you previously had to, as a business, fill out 20 full customs fields on a piece of paper, you will not have to fill a single one now, because it will be a responsibility of HMRC to ensure that those goods are properly it will be still your responsibility to pre-declare the goods that you are moving, but it will be the responsibility of HMRC to then fill out that effectively that customs form for you. So that will significantly change practically for businesses. The other point I would make is that the scope of the trusted trader scheme will also be expanded, and I think it's really, really important, because previously for a business which was moving goods from GB to NI, it had to have, for example, physical premises in Northern Ireland to be able to qualify for that scheme. That's no longer going to be the case. So effectively, more or less any GB-based business will be able to qualify for the scheme. There will be some initial requirements to be able to do that, but those requirements will ultimately outweigh any kind of benefits from participating in the scheme. So I do think this will make a real difference, and I'm actually really glad to see that the EU has been able to take a more proportionate approach and more risk-based approach to any kind of controls and requirements that are necessary for movement of goods, because I do think it's the right approach to be able to treating the goods based on final destination.
Okay, thank you very much. Andrew, would you like to?
So several quick points. I think the outcome now on the general application of the green lane, red lane idea is much, much better than when I originally proposed it in March of 2018. It's moved on in a much more pragmatic way. I think I would look at it as glass half full, as something which with experience, trust, the opportunity is for the concerns that James has raised in particular to diminish, and for the more things to normally be accepted in the green lane as a matter of practice. I think it's not that surprising, if you look at it tactically, that the default is the safer option, given that the UK agreed definitions of at-risk and an approach to agri-food in December 2020, said they were happy with them at that time, and within 8 weeks were desperately unhappy with them, and that was a major U-turn by the UK government at that time, not based on the actual experience, but given that the grace periods had applied, but on what I would regard as tactical opportunity. So trust was low to achieve this and build trust, and I think part of what the really, really important benefit of the agreement that's been reached is a massive improvement in trust, and for that to build and grow is important. I was also, like Jess, surprised. I did not include agri-food goods at all in my original green lane, red lane proposals in March of 18, and picking up something James said earlier, the advocates of alternative arrangements in the autumn of 2020 they acknowledged there was no, I would put it this way, that you can't stop a pathogen with a camera, and the purpose of the SPL's rule is to stop disease. And so when Prime Minister Johnson proposed the full application of EU law and that all agri-food goods would come into Northern Ireland through border control posts in his paper of October 2019, that was a very black and white expression, but it was safe and logical. If the Prime Minister was to protect, as he put it in that paper, to protect the island of Ireland as a single epidemiological zone. So we've moved on a long way from that, and the ability of the EU to find a different way to manage those risks really solves an immense problem. Because the agri-food bit, we knew as Northern Ireland Civil Service through 2020 was a really difficult thing. So I think this is much better than it might have been. Yes, there are continuing difficulties. It's been, I think, oversold as in too simplistic a way, but looked at in detail, it stands as better than anything else I've ever seen in this context.
Thank you, Nuala. Lord Dodds, online. Nigel?
Thank you, Chair. And I just wanted to come on to the issues then of state aid and VAT and excise. So the government, the British government proposed at one stage that state aid should be taken out of the protocol altogether. There was no need given the arrangements under the Trade and Cooperation Agreement. We've now ended up in a situation where there's no change in relation to the legal position on state aid, but there's been a declaration on the application of Article 10.1. So I just wanted to get your views on what the status of that declaration is and what change, if any, there is in the legal position regarding state aid rules for Northern Ireland. Secondly, on VAT and excise, just comments on how you see any changes there in terms of how they apply to Northern Ireland, and also this UK-EU cooperation mechanism, which seems to give a greater role to the EU in relation to the wider issue of taxation in the UK as a whole. So I'd be interested in your comments on that. Maybe start with James, since you're quite an expert on state aid stuff.
Yeah. Certainly not an expert on VAT, so I'll limit my remarks to state aid. So you're right, Lord Dodds, that the provisions do not change. So there's no change to the provisions of Article 10. And what that means is that the EU state aid rules apply not just in Northern Ireland, but to the UK as a whole. Right? Very important distinction between Article 10 and many of the other provisions of the protocol is that the formula is that it applies to the relevant rule applies to the UK in respect of Northern Ireland is how it's typically framed. That's not used in respect of Article 10. The EU state aid rules apply to the whole of the UK. Right. And so with Article 10 in place, we now have two competing subsidy regimes, one piled on top of the other. One is our Domestic Subsidy Control Act 2022, which we introduced, and that reflects the obligations of the UK under the Trade and Cooperation Agreement. And then on top of that, right, accepted by the Windsor Framework, we have the EU state aid rules, which, as I said, apply to the whole of the UK. So what the protocol did and what the Windsor Framework does also is talk about the circumstances in which the state aid rules, apply to the whole of the UK. So they apply to the whole of the UK, but there is a jurisdictional sort of test that they only apply to the whole of the UK in certain circumstances. And under the protocol, those circumstances were that the relevant aid measure had to affect that trade covered by the protocol, i.e. essentially north-south trade in goods or electricity. The new formulation, which is not a change to the protocol itself, but is a joint declaration, and I think probably amounts to the same thing, is that there has to be a genuine and direct link to Northern Ireland, and that has to be material and not merely hypothetical, and that sales in Northern Ireland of themselves are insufficient, and there has to be an economic effect of the aid, right, in Northern Ireland. So we've essentially got a group of words which have been piled on top of each other to say, when do we have a situation of the EU state aid rules applying to a GB or UK aid measure? They have to have that sort of strong connection to Northern Ireland. And that's an improvement on what we had before, certainly, but I think it creates a number of problems. The first problem, which is very underestimated, is that the UK is competing increasingly in an environment for international mobile investment. The UK, uniquely in the world, has got two subsidy control regimes, right? The EU rules and the UK's own rules. And under the UK rules, you can deliver certainty, and under the EU rules, you can deliver certainty, but that requires you to notify the European Commission. And so the difficulty will come when you have a project in the UK, say a battery factory in Sunderland, that receives aid. Does that engage the Northern Ireland Protocol? Does selling the cars in Northern Ireland that come from that battery factory, is that a sufficient link to Northern Ireland to engage the protocol? So beneficiaries' sales on their own might not be enough, but what about that plus a subsidiary, that plus a branch or a dealership network? There has to be an economic effect in Northern Ireland. What sort of economic effect? What's that? Is to be litigated. And so you've got a problem with a battery factory, let's say in Sunderland. The UK government issues it with a subsidy. It approves it under the UK's own Subsidy Control Act, and then you have a latent risk lurking under the surface. Did you or did you not infringe the Northern Ireland Protocol Windsor Framework by not also notifying it to the European Commission? And the problem is, unless you notify it, right, and if you won't know, right? And the limitation period for that answer is 10 years. So you're asking an investor to take that risk essentially for a 10-year period that their subsidies are not are potentially challengeable. If you solve it by notifying the European Commission, you will give the European Commission, and I, having worked in this area for 20 years, have a certain degree of cynicism, right? You will give the European Commission the decision about what amounts to a sufficient and material connection to Northern Ireland, right? They will decide that point. And the only court you can appeal that point to is the European Court of Justice, which I can confidently predict will give you an expansive interpretation of that. Right? So the decision or the omission to leave the state aid, the EU state aid rules applying on top of the Subsidy Control Act. And bear in mind, the Subsidy Control Act reflects the arrangements of the TCA, which the EU has accepted as sufficient to generate a level playing field. Leaving the two on top of each other is a very serious mistake.
Thanks very much, James. Maybe go on to Anton and then Jess and Andrew about, maybe on the VAT aspect of it, particularly.
I mean, just the first thing on state aid, I would say I was surprised that the Article 10 was not amended, because I thought I understood why Article 10 was drafted in the initial context, which was the UK did not at that time have a domestic subsidy control regime. That was 2019, but the circumstances have changed, and we do have quite a robust subsidy control regime after Brexit. And there is a provision within the withdrawal treaty with respect to what the Joint Committee can do, Article 164, which can address circumstances not foreseen at the time of signing the treaty. So I had expected that the negotiators would have used that provision to amend that article for the reasons mostly that James outlined, because it does potentially create difficulties around certainty and stability for businesses and investors. But I do think that this will ultimately be settled in courts because of the ambiguity that this provision creates. On VAT, I would say that the EU VAT regime still applies as a default to Northern Ireland, but there is a set of quite broad and, I would say, ambitious exemptions from that EU VAT regime, and there is now more flexibility to set VAT rates for Northern Ireland in a way that are more consistent with VAT rates in the rest of the UK. And there are certain ways of doing that, including quite a wide exemptions for SMEs and for alcohol duties and so on. So there is a degree of flexibility that wasn't there previously in the original protocol, but the EU VAT regime still applies as default.
Thank you.
Yeah. So I think the original protocol did actually give quite a lot of flexibility on VAT. It just wasn't used, would be kind of my interpretation, in that the Joint Committee is empowered to adopt measures in relation to VAT where the application of the EU regime could have implications for the UK internal market. And we've seen that with the exemptions, for example, on some of the kind of environmental policies and also in alcohol duties and things like that. So I don't think we actually needed the Windsor Framework in order to get those exemptions. They could have happened at any point, but obviously the politics prevented that happening. So I think this is more the Joint Committee using powers that are existing under the protocol rather than necessarily creating a whole new set of arrangements, although as Anton said, there were the kind of blanket exemptions for SMEs and also this enhanced coordination mechanism, I think in part to try and facilitate future exemptions where they might be necessary. So what we've got is a case-by-case approach at the moment, and I think one thing we need to make sure is that where there are legitimate cases going forward, that we do see further exemptions and there are those discussions taking place, because as Anton says, the default is that the EU VAT regime applies.
Thank you, Jess. Andrew.
Nothing really to add to the technical points. All I would say very briefly is that I could understand the EU being cautious about these things because they've been clear all the way through that they've not been in doubt that the protocol was giving Northern Ireland a unique set of economic advantages in terms of the general issue of dual market access, and therefore to be cautious about issues of level playing field and competition has a rationality. I defer to the technical points that others have made on how that works out. That's only a broad tactical point.
Thanks very much indeed. Thank you, Lord Chair.
Thank you, Lord Goss. I want to move on now to talk about regulatory divergence. Lord MP, over to you. You're muted, Reg.
No, I think I'm off. Okay.
You're off now.
Could I ask the panel, what is the significance of the Windsor Framework for regulatory divergence, both east-west and north-south? To what extent will the Windsor Framework protect both Northern Ireland's integral place in the United Kingdom's internal market and its unique access to the EU single market? Divergence is something I've been concerned about and the committee's taken very seriously over the last year or so. So I'd be very interested in the witnesses' response to it, please. I'll start with Jess.
Great, thank you. I've also been very interested in divergence, not just between GB and NI, but within the UK internal market in terms of Scotland and Wales as well. So this is something I've been thinking a lot about. And to that extent, I think what the Windsor Framework does is basically allows more GB-NI divergence to be tolerated in the areas in which the UK is most likely to diverge. And here I'm referring to specifically some of the SPS regulations. I think that exemption for retail goods to not have to comply with EU law in areas that aren't related to animal health is a really useful development in order to allow GB, or in this case specifically England, to implement some of its plans, for example, for gene editing, to prevent challenges that might arise, for example, of changes to EU law on things like labelling. I think actually the Windsor Framework helps resolve a lot of those problems and allows the UK or England, more specifically, to diverge in those areas without it immediately meaning that it's much more difficult to sell goods to Northern Ireland. So I think that's a really positive development. Obviously, that exemption doesn't cover all regulatory areas, and I know one of the concerns raised earlier in the debate on the statutory instrument was around manufactured goods, the fact that they will still need to comply with EU law. I think, as the command paper itself points out, actually in areas like product standards, a lot of those regulations are informed by international standards, and therefore we wouldn't actually expect a huge amount of divergence in those areas anyway. So I think that's less of a problem. I think this particular exemption for SPS is particularly important. In terms of how much the Windsor Framework will protect the internal market, I think one of the challenges here is that the UK internal market is still a very new and contested concept, particularly around between Scotland, Wales, the UK government, Northern Ireland. It's a bit difficult to test what exactly that means, because I think there is some extent in which particularly the Scottish and Welsh governments might like the opportunity to have sort of more regulatory barriers in some way, and to some extent are a little bit jealous of the fact that Northern Ireland can prevent the entry of certain goods if they don't meet EU standards in a way that they can't, because they argue that it could undermine their own kind of regulatory standards. So it's quite difficult to judge exactly whether that test has been met. But certainly I think these arrangements permit more divergence. Whether that will be desirable to all businesses at all points, I think, is a slightly different question.
Thank you. Anton.
Thank you very much for that question. I think it's a fascinating issue which actually arises in this context. And what I would say is there is one problem that I can envisage, and that is a problem of competition, actually, in this context. If you imagine a scenario, and just to take just as example a step further around gene editing, if GB decided to change its gene editing standards as the government intends to do, but the EU would not reciprocate, which obviously it has its own processes for deciding what it does do, then you will essentially end up with GB producers being able to lawfully place their products, which are of a slightly different standard, on the Northern Irish market, while Northern Irish producers still have to produce the same product, but done to a different standard. And that standard may be higher or lower, depending on what exactly is the nature of that legal change. But it might actually create, in my view, problems around competition within the Northern Irish market on its own. And it raises questions of consumer choice and so on. I'm not a consumer protection expert, but it seems to me like potentially quite an important issue which has been slightly underlooked in this whole context. And I think at the end of the day, it will all really depend on how well the new domestic internal market surveillance regime works in practice. There is a whole new office for internal market, and I'm presuming that office, as one of its responsibilities, will monitor some of those questions and how they operate in practice. But I think it will be quite a tricky job, actually, to do it well. I think the other point I would make in this context of regulatory divergence is the risk that the retained EU law bill raises in the context of the Windsor Framework. And I'm of the view that the retained EU law bill is fundamentally incompatible as currently drafted with the Windsor Framework, and it does require substantive amendments if it is to be made compatible. And there are three very specific reasons for that. One of them is the fact that a lot of this EU legislation that would be subject to the sunset clause is essentially within the scope of the amended protocol as it stands right now, even after the latest changes. The other problem, which is I think much greater than that, is the fact that the withdrawal treaty requires the UK government to produce the same legal effects for any new EU legislation within the protocol as for any member states, essentially. And again, the retained EU law bill would fundamentally change the nature of how essentially retained EU law is treated within the UK legal order, which I believe is incompatible with that commitment. It's Article 4 of the Withdrawal Treaty as it stands. So I think it does raise a whole set of separate questions which I think need to be looked at properly. And I do think the government needs to take a proper reflection of how the Windsor Framework requires further changes to the bill as drafted at the moment.
Thank you, Anton. You started a few hairs running there.
Yes, with various genetic modifications, those hairs. I have nothing to add technically. Just a reminder that New Decade, New Approach was very clear on the commitment to unfettered access for NI2GB, but the sentence about Northern Ireland's as an integral part of the UK internal market is in the context of the application of the protocol. That's explicit in NDNA itself, and so I only mention that because the issues that have been raised by the other contributors are real and will apply, and the question is how collectively and operationally we can minimise the difficulties that will arise. That's all I would want to add at this point.
James?
I've got very little to add to the comments that have come before. So I think the issue, exactly that issue of the Northern Ireland businesses not benefiting from changes to UK regulation and yet facing competition from goods that are produced to UK standards is a real problem. I think the second comes from the question that we discussed earlier around the fact that the Stormont break doesn't anticipate significant consultation. It operates as a break at the end rather than as a formal role of consultation during the process of legislative development. And I think one of the consequences of that is that insofar as things come up in working groups or at an official level, the EU will take the view that the way that the UK can solve any problems it's raising in that context. So if you change the law, it'll harm Northern Ireland in ABC way, then the EU's response will be, well, the UK is in a position to fix that by tagging along too. And so I think, it will create a natural drag-along effect, I think, which is, it's sort of in the nature of it.
Richard, you had a question to ask, and then you're going to then it's you to ask the question anyway.
Yes, thank you, Lord Chair. It's just a question to Anton in relation to the EU Retained Law Bill. In fact, I had some amendments to it to do with Article 2 of the Protocol to do with human rights and equality and environmental considerations. The Minister, Lord Callanan, kept insisting that there would be no incompatibility between the Windsor Framework and the EU Retained Law Bill. So if you have any sort of background information on that, that would be very useful to the committee. And could I make a suggestion, Lord Chair, if you could provide us with that, that would be of immense help.
I can definitely provide that in writing after the session, but I would just make a brief comment. I mean, there is a very easy way of dealing with this problem, actually, and that is carving out legislation which is required under the protocol, the amended protocol now, to be exempted from provisions of retained EU law bill to the extent that those concerns arise, because that would essentially deal with that problem. Of course, the approach that the government took was to carve out NI-specific legislation from the scope of the bill, but that does not lead, that does not deal with the problem, I'm afraid, of UK-wide legislation which has applicability in Northern Ireland, and equality protection is obviously one very good example of that. Yeah. Mm-hmm. But standards for manufacturing products would be another example. Those are not dealt with by NI-specific legislation. Those are dealt with by UK-wide standards. So there is a whole set of examples, I think, which would fall in this camp.
And thank you. And if I could move on then to the question on veterinary medicines and human medicines.
And can I just say we're running up against the clock, but we'll go on, if it's all right with everybody, we'll go on just till the very latest 10 past. We've got a question from you, Baroness Ritchie, and then Lord Thomas.
The Windsor Framework already deals with human pharma or human medicines. So how would you assess the current situation with regard to veterinary medicines? and what steps need to be taken to agree a long-term solution before the expiry of the grace period at the end of 2025. And I think in the commentary associated with the Windsor Framework, there was indications that they would hope to reach an agreement in terms of a permanent agreement. And also, what is your assessment of the Windsor Framework provisions on the supply of human medicines to Northern Ireland? And do you think they deal sufficiently with the issues previously raised by industry in relation to the protocol? And many of those issues were raised by those involved in the human pharmaceutical industry to our particular committee in our last inquiry. So if I could start with Jess.
Thanks. I mean, in the interest of brevity where it comes to veterinary medicines, I think it's clear that a solution does need to be found on that, and that was, as you say, the intention of that was signalled in the agreement. I'm not exactly sure why that wasn't part of this agreement, but I think it's important that that issue gets resolved. In terms of the provisions on human medicines, I think this agreement does go a long way to resolving a lot of the issues that some of the industry have been raising, particularly around being able to produce a single pack in order to sell medicines both in Great Britain and Northern Ireland by removing the requirement to comply with the Falsified Medicines Directive. That's been achieved, and I think that's really helpful. I think allowing the MRHA to regulate for the whole of the UK, again, particularly in the issues around innovative and novel medicines, is a really positive development, and again addresses some of the concerns of industry. And that, coupled with some of the recent announcements in the budget as well around regulatory cooperation with the EMA and the FDA, I think also go further in ensuring that we're unlikely to end up in a situation where certain medicines aren't accessible in Northern Ireland. So that seems to me to be very positive. It doesn't go quite as far as the UK might have liked in the command paper in terms of removing medicines entirely from the protocol. But one of the other things I've heard very clearly from industry, and particularly in the medicines industry, where pharmaceutical companies are often having to take regulatory decisions for several years in the future, is that actually what's really important to them is certainty, and hopefully this has gone a long way in providing that.
Thank you. Anton?
I would just add to that actually medicines is one example where we see a genuine example of dual regulatory regime now, where Northern Irish businesses will be able to benefit from authorizations by both the European Medicines Agency but also MHRA, which is a domestic regulator. So I do think this is a very good arrangement actually for Northern Irish businesses, and it does open up possibilities, and it does introduce a degree of regulatory competition, which can be a good thing, because it can encourage regulators to think differently and more creatively about approaching the same regulatory objectives but in a slightly different way. In relation to veterinary medicines, I think this is still an outstanding question essentially, because it is dealt with by a temporary exemption that has been passed by European Parliament, but it does not provide a permanent solution yet. So I'm hoping that the joint committee at some point would look at this issue again and address it by essentially an extension or turning into it into a permanent solution.
Thank you. James?
I have nothing to add to Anton's comments.
Thank you. And Andrew?
Likewise, in the interest of time, nothing to add. Thank you.
Thank you. Lord Chair?
Thank you very much, Baron Street. Lord Thomas.
There are two competing views about the role of the European Court. The EU, in the briefing that I referred to, said there's no change to the role of the Court of Justice of the European Union. The Court of Justice remains the sole and ultimate arbiter of EU law. On the other hand, the UK government says that the Stormont break and the UK's veto in the Joint Committee can only be challenged through independent arbitration mechanisms, not the ECJ, removing the ultimate authority of the ECJ in areas in which it would affect day-to-day lives. And there are other statements made by the British government that we've got rid of the ECJ. I understood the arbitration arrangements which are referred to do of course contain the possibility of an arbitrator seeking the views of the ECJ on a point of European law. That's how it's supposed to work, isn't it? And I've also myself suggested that if, at least for face saving, you put that any point of English or UK law should be referred to the Supreme Court of this country. But never mind about that. What do you think about the arbitration situation and the role of the ECJ? James?
So the EU's position is closer to the truth, I think. So there is no change substantively to the role of the ECJ, except in the context of the Stormont break. So the Stormont break does, and that a dispute arising under the Stormont break, which would be whether or not the UK was entitled to exercise it. So, the various procedural requirements we've talked about, together with the substantive requirements of significant effect and all of that. That dispute is raised before the arbitral tribunal, the bilateral arbitration mechanism in the withdrawal agreement, rather than directly to the ECJ. Whereas under the withdrawal agreement, failure to implement a rule would have been, treated as if it were a member state failure, and that would have gone straight to the ECJ. So that is a change. But other than that, there is no change to the role of the ECJ, in my view. The second point is that insofar as you are going to have any mechanism based on EU law, the questions of EU law have to go to the ECJ because of the decisions of the ECJ itself. Right? In Achmea and in other judgments, the ECJ has been very clear that it is the only court that's competent to interpret EU law. So if you have EU law in your agreement, you have the ECJ in your agreement pretty much to the same extent. And the only question then is the procedural route by which you reach the ECJ. And as
effectively, the arbitration procedure has been placed in between.
In respect to the Stormont break?
The Stormont break has been placed in between the...
the Stormont break, which only applies in the circumstances we've discussed earlier.
Yeah.
Right? So that's a new law where the substantive provisions, allowing its application apply. Otherwise, the ECJ's position as under the protocol is unchanged.
Right. Yes.
I broadly agree with James's assessment that there has been no material change to Article 12, which is essentially granting the European Court of Justice jurisdiction over provisions of EU law that apply to Northern Ireland. It also means that UK courts which are dealing with any domestic disputes relating to potential application of EU law would still be empowered to, and in some cases under obligation to seek preliminary reference to the European Court of Justice with respect to those issues, which I think is really important, again, in the context of retained EU law bill, which does contain some provisions for giving UK courts more discretion to decide how they want to approach questions which had been previously dealt by the European Court of Justice. So I can see a potential for some inconsistency here. What I would say is that from a business point of view, if you are a business in Northern Ireland which would feel that their rights have been infringed essentially by another company within the EU and would seek a remedy, it is in the interest of that business to ensure that they receive the same remedy as any other European business facing a similar issue. And that is essentially ensured by way of ultimately asking the European Court of Justice for its verdict. So I think from a business point of view, it does provide a degree of certainty and stability. And it's not necessarily a bad thing. But I do appreciate that there has been no change to that provision.
So the Northern Ireland business would want to go to the European Court to resolve an issue which involved, for example, the application of certain regulations. Is that right? I mean, it's a benefit to business in Northern Ireland, is it?
I think it's a benefit to ensure that businesses that are competing in the same market have access to the same remedies at the end of the day if there was a concern for that business. And that's ultimately where you can get the final recourse is through the European Court of Justice. So I can see that silver lining of this arrangement.
On the other hand, if the contract, a contract had been agreed to be ruled by UK law, then of course they'd use the UK courts to resolve disputes.
That's right. But as if that dispute was about application of EU law under the amended protocol, UK domestic code would still have to ask. Could end up in a scenario that the UK court might have to ask the European Court of Justice for its opinion on the points of interpretation through the preliminary reference procedure, which does exist.
Yes, do you have any comments? Andrew?
No, I do add that points well made.
Right, well, I'm very grateful. Thank you.
Well, thank you very much, all of you. It's been extremely helpful, and it's got our new inquiry off to an extremely good start. And there are a lot of quite tricky and important issues to consider, and we started well. So thank you very much indeed for the evidence that you've given us. We're extremely grateful. And I declare this formal part of the meeting closed.